Good day to you all at this diplomatic discussion on recognizing and strengthening rights of future generations from the ICJ climate case to the UN Summit of the Future. I look forward to delving concretely into ways international courts and tribunals have taken center stage in global efforts to address the existential issue of climate change in a way that prioritizes intergenerational equity and is led by young people themselves. For more than 5 decades, science has been providing stark warnings about the chemical and physical consequences of greenhouse gas emissions. Sadly, the short-sighted and economically driven policies of many states meant that little heed was paid. And today, Vanuatu's people suffer from the insidious rise in sea levels that eats away at our villages, ocean acidification that is dissolving our reefs, increasing sea surface temperatures, bleaching our corals and sea grasses, landslides that erase entire villages and plantations, and prolonged droughts that shrivel and kill our subsistence crops before they can even be harvested. The political denigration of science was on full display at UN climate negotiations in Germany a few weeks ago, as parties refused to acknowledge that the Intergovernmental Panel on Climate Change AR6 report is the most comprehensive and robust assessment of climate change that we have, and that we must act on its message to limit warming to 1.5 degrees Celsius for our own and future generations. This result of inaction is harm to those not responsible. Climate suffering that is being experienced right now and will be exponentially worse for those born today and tomorrow. Friends, this is not just a Vanuatu problem. What we are experiencing now and have faced for many years, we see the rest of the world beginning to feel. We empathize with you in the United States and the rest of the developed world and hope that we have the collective courage to turn this canoe around. 7 years ago, 196 countries adopted the Paris Agreement, the international treaty many hoped would finally take us off the path of planetary destruction. Countries around the world celebrated the landmark first step towards what we hope would be accountable, transparent, and life-saving requirements to reduce the impact of global warming. But unfortunately, the pledges, promises, and commitments made under this agreement take us well beyond the safe operating limit of 1.5 degrees. Little effort has been expended on the human rights-related violations linked to climate change, and countries still tend to see the Paris Agreement as the only international law relevant to climate change. International law is broad and comprehensive, and the UNFCCC's Paris Agreement is certainly not the only treaty we have which contains obligations of states to prevent climate harm and protect human rights. That is where Vanuatu's transformative International Court of Justice initiative comes in. With the lack of ambition seen at the UNFCCC, what is urgently needed now is clarity from the highest judicial authority on what are those other legal binding climate and environmental obligations and the consequences for states who fail to uphold them. Advisory opinion from the International Court of Justice will draw a clear line between what is an acceptable outcome of UNFCCC climate negotiations and what is a non-negotiable legal responsibility for all states. In our view, climate action is not a mere matter of state discretion. It is an exacting requirement under international law that comes with enforceable consequences. Specifically, we see climate-relevant obligations in the Charter of the United Nations, the Universal Declaration of Human Rights, the International Governance on Civil and Political Rights and on Economic, Social, and Cultural Rights, the Convention on the Rights of the Child, the United Nations Convention on the Law of the Sea, the Vienna Convention for the Protection of the Ozone Layer, the Montreal Protocol on Substances that Deplete the Ozone Layer, the Convention on Biological Diversity, the United Nations Convention to Combat Desertification, and more. But how can the obligations and the wide body of existing treaties be applied to climate change? Pacific Island University students asked themselves and others this question. They brought ideas to the government of Vanuatu, and we listened. Those discussions grew into a truly international call for clarity and for justice. Vanuatu accepted the call from our youth and has since been leading the campaign side by side with them for an advisory opinion on climate change from the International Court of Justice. The United Nations International Court of Justice is the only principal organ of the United Nations system that has not yet been given an opportunity to help address climate crisis. To get to the court, Vanuatu assembled a core group of 18 countries from Global South and Global North, including Germany and 3 other European nations, to draft a relevant and impactful question to the court. We held multiple consultations and took on feedback in good faith from all corners of the globe. What many told us was wishful thinking became a reality when on 29 March 2023, 132 co-sponsoring nations tabled the resolution at the United Nations General Assembly. Historically, for an ICJ request, our resolution was adopted by unanimous consensus. You can read the full resolution on www.vanuatuicj.com. But in summary, we have asked the court 2 simple questions. First, what are the obligations of states to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gas? Second, what are the legal consequences for states where they, by their acts and omissions, have caused significant harm with respect to A, small island developing states and other vulnerable states, and B, peoples and individuals of the present and future generations? It is our view that these questions should have been asked long before now, and that the answer given by the world's highest court will help countries get back on track in upholding the rule of international law and bringing human rights thinking into energy and climate decisions moving forward. I want to be very clear that this initiative is not intended to name or shame any particular nation. And despite being brought to the UN's highest legal body, we are not suing anybody. There will be no winners or losers, and no state will be required to do anything as a result of the advisory opinion of the court. Importantly, we are only asking for clarification of legal obligations already agreed to under international law, and we are not creating new law. The question is also forward-looking, considering both historical emissions, but also emissions of today and the future. The resulting advisory opinion will help states revise and enhance their nationally determined contributions under the Paris Agreement and strengthen domestic laws and policies. The advisory opinion will likely identify gaps in international law, which will help us as we build and improve our multilateral climate negotiations process. The advisory opinion will also ensure we base our relationship on the adherence to the rule of international law. As we have seen with the recent destabilizing war in Ukraine, we must prioritize an international legal framework which is clear on what is acceptable state behavior and what is not. The rule of law is foundational to the United Nations and to its mission of peace. Vanuatu was so proud to partner in this initiative with grassroots, youth movements, and indeed over 2,000 civil society organizations from around the world, as we work to drive the forward-looking, indeed intergenerational question now before the ICJ. We will continue to see youth as our closest legal and climate ambition allies in the ICJ process and beyond. So what is next? On 25 April 2023, the Registrar of the International Court of Justice formally published its notification that A, It fixes 20 October 2023 as the time limit within which written statements on the questions may be presented to the court. And the notification also fixes 22 January 2024 as the time limit within which states and organizations having presented written statements may submit written comments on the written statements made by other states or organizations. So right now, states, UN organizations, intergovernmental organizations, and others are invited to prepare submissions with their legal perspectives on the two questions. Sadly, the ICJ will not accept submissions from NGOs, but Vanuatu and many other states are committed to including non-governmental voices in our own submissions, so there are creative ways to ensure maximum inclusivity in the process. What is essential right now is to ensure that, first, all states in the Global South are empowered to make submissions, and second, that the submissions highlight the substantive obligations found in international law. Let me explain. Many countries in the Global South have never engaged in the ICJ and are unfamiliar with its processes. Many do not have legal experience in preparing ICJ submissions and lack access to the evidence and legal drafting experience. We need to lower the barriers to entry for these countries and provide as much pro bono legal and technical support as possible so that the court hears from all states who have contributions to make. I appeal to you all and your networks to contact us with offers of support as we are receiving requests from countries daily. Substantive obligations should be the focus of these submissions. We already know of some states planning to make submissions that there are only procedural obligations related to climate change. We need as many states as possible to highlight specific international instruments and principles which lead to substantive obligations, which in turn trigger state responsibility to act. State submissions have an opportunity to emphasize harm caused based on evidence demonstrating a causal chain up to the whole system through to the source of the emission. Importantly, submissions should strive to answer both questions, the question of obligations as well as the question of the legal consequences, and linking this to the source of international law that the court is asked to look at. As of today, at least 50 Global South countries have confirmed they will prepare submissions, but they need help. Vanuatu is convening a rights shop for Pacific Attorney Generals next month, and these have been requested in Asia, Africa, the Caribbean, and Latin America, pending funding. If you have networks or contacts with influence, now is the time to mobilize well before the 20th October submission deadline. Excellencies, ladies and gentlemen, friends, soon the world's highest court will give us the clarity we all need to do more. We are out of time in Vanuatu, and our children need us to demonstrate the leadership demanded. Beyond the ICJ, Vanuatu is taking other actions to strengthen and transform international law for climate action. Vanuatu and a group of the like-minded nation has also submitted a request for guidance from the International Tribunal of the Law of the Sea, ITLOS, on how greenhouse gas emissions are linked to obligations under the law of the sea. We expect that this advisory opinion will be released first and feed constructively into the ICJ Justice's consideration. To address the clear gaps in existing international law, Vanuatu is now leading the initiative to criminalize ecocide, which is the unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. Criminalizing ecocide as a fifth crime under the Rome Statute of the International Criminal Court would add environmental damage alongside the most heinous activities known on our planet. genocide, crimes against humanity, war crimes, and the crime of aggression. With the crime of ecocide able to hold individuals to account, including state leaders or fossil fuel CEOs, we will have clear guardrails of acceptable behavior towards the environment, presenting a substantial deterrent. Finally, addressing a major gap in the UNFCCC system is the need to legally motivate the phase-out of fossil fuels. Vanuatu simply cannot accept the continued expansion of fossil fuel production or an expansion of subsidies propping up this dirty and planet-killing source of energy. Vanuatu was the first nation to call for a fossil fuel non-proliferation treaty, which will complement and indeed strengthen the implementation of Paris Agreement, which has not designed to address the source of greenhouse gas emissions and climate pollution, oil, gas, and coal. Just as addressing the risk of nuclear weapons, landmines, and other threats to humanity required an unprecedented level of international cooperation, so does the probe of phasing out fossil fuels and accelerating the adoption of clean, low-carbon solutions fall to us today. This new international legal mechanism will facilitate the energy transition in a way that is fair, fast, and sufficiently financed. We know this won't happen without the Fossil Fuel Non-Proliferation Treaty, because without an international agreement, each producing nation will continue to argue they should be the last one to produce the last barrel of oil because they can produce it in a clean way. Momentum for Fossil Fuel Non-Proliferation Treaty is growing. With Vanuatu and Tuvalu in the lead, there are now 7 nations joining us, 550 parliamentarians, more than 80 cities and sub-national governments, 101 Nobel laureates, more than 2,000 civil society organizations, the World Health Organizations, more than 1,000 religious groups, and even the Senate of the state of California just passed a resolution endorsing the negotiation of this new treaty. With that, I thank you again for joining Vanuatu, one of the smallest but now loudest voice on transforming international law as a tool to motivate the climate action demanded by and necessary to protect young people. I particularly thank the government of Costa Rica and the Normandy Chair for Peace for hosting this discussion with us. We share a belief in accountability, and Vanuatu looks forward to further collaboration with you to shape, implement, and enforce the law. For all here today, know that in Vanuatu you have a staunch ally committed to utilizing the powerful tools of international law for climate justice and intergenerational equity outcomes. Thank you, Thomas.